Turn it up? I'm not sure I can do that. I'm not sure it'll move up either. Maybe we'll...
I think it's going to be okay.
How's that? Okay. All right, well, I'm not sure there's enough room for everybody, but welcome. My name is Breck Seiniger, and before I do anything, I have to correct an error. About a year ago, I was recognized, if you will, as a roast, and I didn't recognize my wife, Julie, who has always been here to support me, and I wouldn't be here today if it weren't for her. So I can check that off. Thanks for coming. Let me tell you what I'm going to be talking about. I want to tell you a little bit about my background, why I'm running for one of the seats on the Idaho Supreme Court. There are 2 seats that will be up for election on May 20th, 2014. One is presently held by the Honorable Joel Horton, and the other is presently held by the Honorable Justice Warren Jones. At this point in time, I don't know which one I'll run for because I don't know whether they'll be announcing, and so I'll wait. I want to tell you a little bit about what I see, some of the issues that need to be addressed with respect to the Idaho Supreme Court. And then finally, I want to tell you what I intend to ask of my fellow citizens in the state of Idaho. So my background is I grew up back east, primarily in Massachusetts. I went to the University of Massachusetts. My first job out of school that was of any consequence was in government. I worked as a speech writer for Silvio Conti from Massachusetts. He was a Republican. It was an interesting time to get an interesting view of government because it was right during Watergate, and it was a fascinating thing to see, including one of the things that I guess I'll never forget is Richard Nixon getting on the elevator to go up to give the last State of the Union address he ever gave. When I left the East, and I decided I really wasn't interested in politics per se, because one of the things I found back there was that when you met anybody, the first thing they asked you was, "Who's your man? Who's your man?" In those days, there weren't enough women, unfortunately, that they asked, "Who's your person?" And I thought, you know, that's really not what I want to devote my life to, derivative power or respect. I wanted to be a lawyer and represent average individuals. So I came out to Idaho, and I went to law school here. I got a job with the Latah County Juvenile Probation Department, and I worked there for 4 years. I worked my way through law school, and I had a great experience there. When I was done, I took my first job in Pocatello, Idaho, with the law firm of Racine, Hunley, and Olson, and that was in the late 70s. And I got to meet a lot of great people, a lot of great judges over there, and made some very good friends. But I decided I wanted to come to Boise, and so I moved here in 1980 and I set up a practice. I'm in my 4th decade now, and it's been a tremendous opportunity and honor for me to have had average Idaho citizens, most of whom have to work from paycheck to paycheck, put their trust in me. I'm getting a little choked up when I say that, and I apologize, but when you look at, lots of times you look at the judiciary system and it's kind of a top-down deal. You know, you got, in the federal level, you got Anton Scalia and the guys at the top, and it all goes down to the average citizens whose opinions everybody claims to respect, but in my view, it doesn't matter much to them. Those are the people that I've represented, and my wonderful staff has represented. We've taken risks for them, and we've been paid for that, and some things have worked out and some things haven't. But money comes and goes. But the honor of serving people in a system that otherwise couldn't afford lawyers has been great. And it's been great to work in front of the judges and justices of the state of Idaho, for whom I have great respect and admiration. Probably the main issue that I see that faces the Idaho Supreme Court, and that I think is a problem, is the lack of balance on the Idaho Supreme Court. And make no mistake about it, if we want to have impartial courts, we have to have balanced representation on our appellate courts, because ultimately they interpret the law, and it takes a variety of perspectives and the wisdom, the collective wisdom of the bar as a whole. Now, when we talk about that, the vast majority of attorneys who represent the average citizen do not make it through either the nomination process or the appointment process for Idaho Supreme Court justices. The appointment process, I won't go into it at length, but ultimately they're appointed by the governor. In 2009, there was a study commissioned by the National Center of State Courts, and its conclusion was a clear majority, 59% of Americans, say the decisions of their state courts are too often mixed up in politics. Now, when we wonder about, well, how does politics affect the state of Idaho, we raise a question that it's difficult for a candidate to talk about, because there are some very severe and inappropriate restraints on what judicial candidates can say, and I'll get to that in a moment. But by impartiality, I'm not talking about dishonesty. I don't think any of the justices on our court are dishonest. I know them all. I respect them all. I agree sometimes violently with them. But there's a big difference between people who believe that the composition of the court causes it to lean in a direction and really vilifying somebody and saying they're dishonest. And I would never do that and will never do that. And I don't agree with anybody who ever has done that. Let me say this. Of the appointments to the Idaho Supreme Court since 1990, over 85% of those appointments have been from the lower courts of the state. And the one exception to that was from one of the largest firms in the state, who represented, to my knowledge, primarily large corporations and institutions. Okay? So the vast majority of our judges are political appointees, and often without any significant experience in running for office or even maintaining an office. Now that may sound like not much. If somebody maintains an office and they have to pay somebody and they have a staff, and so what? What does that matter? Well, let me tell you why it matters. Because those are the lawyers that understand most keenly why this system has to work for the average individual and has to be affordable. They don't have a huge bank account in the Cayman Islands or Chicago or wherever some of these institutions have them. They have to write a check, usually. And that influences how you see the system at every level, rules of procedure, deadlines, everything like that. I think that's a vital perspective that is missing from our court. When I first started practice, I had the great good fortune to know Blaine Anderson. Blaine Anderson was a justice on the Ninth Circuit Court of Appeals from Idaho. He was from Blackfoot. And one of the things that he told me was the vast majority of justice that's dispensed in the state of Idaho is dispensed in the offices of lawyers. He was very romantic about his days in Blackfoot as a lawyer, and I tell you what, it was shocking to me, but he honestly regretted being on the Ninth Circuit. I could tell he would rather be in Blackfoot. It was clearly service. He was a man that I admired tremendously. Idaho at present, as of today, has 3,664 active members of the bar. The vast majority of those people are lawyers who have to work for people who must pay for the system, who have to write a check, okay? Those people are not represented on our Supreme Court, and they haven't been. Now, what are the problems facing our Supreme Court? Well, first of all, in my view, and this is my own personal opinion, but I have talked to lawyers and judges around the state. There is a departure from the traditional self-imposed discipline on our Supreme Court. What I hear is that, first of all, opinions now contain disparaging comments. And I'm not talking about the most recent case of Neal that has been in the press. I'm talking about regular opinions. When I started out, You didn't see that. Opinions were limited to the facts, and there weren't shots taken at counsel for, well, they could have done this and they couldn't have done that. It was very civil. And our courts preach civility, but civility begins at the top. If the justices on our court write opinions that are unfairly critical and unnecessarily critical of judges or lawyers, they're not displaying the example that they should be. And when I say unnecessarily disparaging, if something must be said about a lawyer so that you understand why the facts that were at issue were resolved by the law that applies, then so be it. But when you have opinions that go beyond the facts and speculate as to what lawyers might have done, I think that goes beyond the pale. Sometimes I get the feeling up there that no matter what a lawyer says, no matter what a lawyer has in mind, they're not going to decide the case that way because they're smarter and they have a better idea. And I can tell you a case, and I realize I'm probably putting my head in the lion's mouth here, but I won a case a couple of years ago, 5-0, that had been thrown out. And I won it, but it wasn't on the theory that I had argued. The theory that I won the case on didn't really make any sense, and I had to go back to the district judge and say, you know, I understand that I got you reversed, but we're going to need to amend the pleadings here because this really creates lots of problems. I do get this feeling sometimes that whatever the arguments are of counsel, they can't really be close enough to the mark. I should have brought some water here. Looks like I have some. I also hear that there are extraneous comments. I heard it was in a court not long ago where a judge said that there are too many extraneous comments in these cases. Now, the reason that's significant to those of you who might not be lawyers is that's called dicta. And the problem is that the way our system works is you get a set of facts, the law is applied to it, and then that's a precedent. Other lawyers read that and they say, well, okay, my facts fit into this scheme or they don't. But when courts say, well, here's what we might do in another situation, that's called an advisory opinion. And dicta really is no more than an advisory opinion. So I think that the court needs to return to the traditional ways, rules that apply to its decisions. I also hear from lawyers that their arguments, when they lose, their arguments and the facts they relied on are not fairly characterized. And again, I want to be careful because of this Neal opinion. I'm not suggesting that anybody is doing this for any purpose to be dishonest or whatever. I'm simply saying that it's a good practice and one that I would follow, that the losing party at least deserves the dignity of having their argument presented and their strongest facts presented and refuted on the merit. Because that way nobody really can claim that anybody hid the facts. And I don't think the judges in our courts hide the facts. As I say, the average Idahoan can be very sure we have honest judges. But I think sometimes these things simply happen because there's a little bit of a lack of discipline in terms of confining the writing of these opinions to traditional rules for opinion writing that are followed in every state and in every federal court. We also have a problem with hyper-technicality, I think. And a good example of that is the recent case of Hall versus Rocky Mountain Insurance Emergency Physicians. It was written by Justice Horton, one of the people that may run against me, and there was a concurrence by Justice Jones. Ms. Hall had alleged that she had been inappropriately touched as a female patient, that her breast had been touched during an exam, and that this was an abuse or exploitation of a patient that violated the Medical Practice Act and the act establishing a statewide standard of care. Justice Horton wrote the opinion. It was basically the case was thrown out, and he indicated that the Idaho Code section 54-1814 that says that you can't abuse or exploit a standard does not establish a minimum threshold because it doesn't establish requirements or qualifications for obtaining a medical license. In the concurring opinion, Justice Jones said the following, and I applaud him for it. He said there is no room for variation in the standard of care when it comes to misusing an intimate and confidential medical relationship for the purpose of exploiting or abusing a patient. Local option abuse and exploitation is obviously unacceptable. And it goes on to say, it particularly goes without saying that any medical profession practicing in the state of Idaho violates the standard of care by sexually abusing or exploiting a patient. Okay. This is what I'm talking about, things being too hyper-tactical. I think Justice Jones had that right. So, and the reason for this is this. The reason I say this is this. Some cases are so expensive for litigants because there are so many roadblocks between the filing of the case and the finish line, which is the trial, that they may well have the evidence, but they can't get there because it's too expensive to get experts and you spend tens of thousands of dollars getting their affidavits just right. I think that's an issue that at least deserves attention, and it's one to which I would give attention. I can't tell you how I would resolve it, and again, I'll get to that. Well, basically, one of the constraints on lawyers is that a lawyer is not permitted to appear to commit to a position on an issue likely to come before the court. Now that's called an announce clause. Those were struck down in 2002 by the United States Supreme Court. And yet that is still maintained in the state of Idaho. So you can understand that, and one of the problems is when you run for one of these offices, you got a law license. I'd like to keep mine. We'll see why that happens. I'm sure it will. I don't accuse anybody of bad faith. But the point is, you have to be very careful about what might appear to be a commitment. Because if I say something looks strange to me, you might think it appears that I've made a commitment. And that's called a vagueness problem. We have that problem. We also have the problem in Idaho that the way the ballot reads is, who shall succeed? And whichever one it might be, let's just say Justice Horton. I'm not saying I'm running against him. This is, who shall succeed Justice Horton? And then underneath it says Justice Horton or Breck Seiniger, not necessarily in that order. But the point is, it tremendously enhances the power of the incumbency. The challenger is almost prohibited from discussing meaningful issues, or at least it's very difficult. So I think that, and the bottom line for that is, not that it makes it difficult for me, but free speech is for the people in elections who have to vote. I think they need to hear what people say. I think that the concern is that that's a power that can be abused. Somebody runs a big billboard and it says, we don't want this guy because he once represented a criminal. But unfortunately, and the U.S. Supreme Court has recognized this, you can't take away free speech and have a prior restraint because you think somebody might say something that you don't like. So, and I guess finally, I think that there are going to be challenges with respect to the streamlining of our system and particularly electronic discovery and some of the electronic filing things that are coming down. And let me just say this, I'm very comfortable in that world. I was, to the best of my knowledge, was the first lawyer in the state of Idaho to ever try a case in Idaho with a courtroom, I think, with a computer in the courtroom. I think it was in 1982, I had an old 286 computer, but the bottom line is, I've worked in that area, and there's a lot that we can do to make justice more affordable and more timely. But what we can't do, and what we must not do, is impose arbitrary time standards that simply put pressure on our judges who are already worked to dispose of more cases faster than they can. We already have a problem with our public defender system. That was the subject of some discussion by Chief Justice Burdick on television recently. So those are just some of the issues that I think are important. Again, because of their rules, let me say I'm not committing, and I'm not appearing to commit to anything. Other than this, what I commit to is the following. First, I will always put principles above politics. I'm not very political now. I ran for political office in the early 80s. I haven't been involved since. Secondly, I am very committed to the idea of balance on the court to achieve true impartiality that happens as a result of unconscious processes, I think, not because of any alleged dishonesty. I'm very committed to total fidelity to our constitutions. I think the United States Constitution, and particularly the Idaho Constitution, sometimes gets short shrift because of some of the rules that have been adopted. Frankly, and I don't say this to vilify FDR, but after FDR, the rational relationship rule that's followed and has been adopted by Idaho simply does not provide enough protection, I don't think. And so that's something that I would at least be willing to look at. And finally, I think we have to have fair and affordable procedures promoting decisions on the merits. So let me get to the punchline here and tell you what I ask of the voters. First of all, I ask you, the voters of the state of Idaho, to consider your opportunity to elect judges and justices who are not compromised by a political appointment process that intentionally or unintentionally seems to filter out the vast majority of lawyers who serve you. Secondly, I ask you to consider the form of the ballot, because you'll see me as not the incumbent, and it'll be very clear who the incumbent is. And I believe that the people of Idaho have the wisdom to not be herded like sheep simply by virtue of the way the ballot appears. Finally, I ask you to do something for me. I don't ask you to give me a lot of money, and I don't even ask you to vote for me. What I ask you to do is find a lawyer that you know and respect and ask them about me. I think a lot of lawyers in the state of Idaho know me. I have been fortunate enough to receive a few recognitions. And I think what they will tell you is that it doesn't make any difference how much money the other guy has, how much support they have, how much influence they have because they've ascended through the ranks, that in the end, in Idaho, it is not the size of the dog in the fight. It's the size of the fight in the dog. And I think that I think most lawyers would tell you there's an amazing amount of fight in this old dog, and it's only because of what has inspired me to be a lawyer. It's a great thing to have a law license. It's a great thing to practice. It's a great thing to have a constitution. But none of it means anything if we're not totally committed to justice and the other worthy ideals that have inspired and built all of our systems. So finally, I say to the people of Idaho, you have an opportunity to take this decision back. And I hope you'll at least think about doing it. Thank you very much. And thanks for coming. Very nice.